we wrap up our discussion of employment law generally and employment discrimination law specifically with a brief overview here of disability discrimination in the workplace. Now, we've got two federal laws that set the minimum national standards for the obligations of employers and the rights of employees when it comes to disability discrimination. But depending on the state you're in, there may be various additional regulations that give added protections or added obligations to the employer when it comes to disability discrimination, and even maybe some local laws, especially if you're in a really big city like New York or Los Angeles or San Francisco. There may be additional things you need to consider to understand your full obligations as an employer and your rights as an employee. But this sets the floor of the standards for disability discrimination, these two federal laws that we're going to talk about. The minimum that applies to all of us throughout the country, assuming you're an employer that is covered by these two laws. So first we have the Rehabilitation Act of 1973. This protects the employment opportunities for people with disabilities with regard to employers who do business with the government, basically. $2,500 or more in government contracts. If you're an employer who does business with the government, then this applies and provides protection for current employees and prospective employees with disabilities. The Americans with Disabilities Act applies to disabilities in places of public accommodations, so it covers more than just the employer-employee relationship. It covers other things like like access to public places, having parking that's accessible to the entrance, having bathrooms that are accessible to people in wheelchairs, ramps accessible to people in wheelchairs, and some other things. So compared to the Rehabilitation Act, it covers more with regard to disabilities, but in the employment context, we can kind of talk about them as basically the same thing because the standards are essentially the same when it comes to people who have people with disabilities and their rights in the employment context. Like Title VII, the ADA applies to employers with 15 or more employees. But again, if you're an employer with like 5 employees, there may be state and local laws and also just other legal concepts that may come into play. So this isn't, if you aren't technically covered by the ADA, that's not necessarily carte blanche for you to discriminate against people with disabilities. There's more legal analysis that needs to be done. So if you're in that situation, don't consult with an attorney about whatever situation you're in, even if the ADA doesn't necessarily apply to you. And also, like Title VII, these cases proceed in a similar fashion. There's an administrative process that is exhausted before you bring a typical lawsuit, going through the EEOC and having them investigate the claims. Now, disability is covered. People with a so-called disability are protected from discrimination under the ADA and also the Rehabilitation Act. So of course it raises the question, what is a disability? Now you see the definition here from the ADA, what is considered a disability. So first we have number 1, physical or mental impairment which substantially limits one or more major life activities. So it's a couple of things there. It can be physical or mental, so mental disabilities are covered as well as physical, as long as it substantially limits one at least or even more major life activities. And we'll talk about in a second what that means. What is a major life activity? And also that there is a record of such an impairment. Or it also applies to people who are regarded as having such an impairment. So if an employer discriminates against you because they think that you have something considered a disability, that person is also covered by the ADA protections, even if they don't actually have that disability, because the discrimination really is the same. They're discriminated against you because that's their perception that you have that disability. So physical or mental impairment that limits or substantially limits major life activities. What is a major life activity? As you can see here, pretty much anything. Quote, caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. pretty much anything you would do as a consequence of being alive could be a potential issue under discrimination law. Now, employers have to not only refrain from simply not considering you for a job because of a disability that you have or that they believe that you have, but also they have an obligation to make accommodations for you if you're going to have the job, if those accommodations are reasonable and don't essentially negate the whole purpose of filling that position. So, like with Title VII, it can't be things that are going to render you unable to basically do the job at all. But as long as they're reasonable, they have to make those accommodations and even maybe put out some expense in acquiring new equipment even to make those accommodations if the person is otherwise qualified for the job. Now, this is a tricky area of law because it's not always very clear what is a, what kind of disability prevents people from doing what kind of job. And that's the case we're going to look at in a second. Yeah, it's something that there's a lot of areas that just, for some employers, have never maybe even been addressed before. There's some jobs that maybe somebody who's blind has never applied for. And so there's going to be a lot of novel issues that you have to navigate. So it's an area where you really want to be careful and get good advice before you make decisions about what you can and cannot accommodate. And this case is a really good example of how that can come to, come back to bite an employer who may be perfectly well-intentioned, but may be a little bit ill-informed. This case is called Keith versus County of Oakland, and this kind of, we could circle back to something else I raised earlier in the little brief video I made about working for the government. He's applying to a government job, and so in this situation, we're just going to be talking about the ADA and how it applies, but the County of Oakland is a government employer, so they also have to consider any constitutional issues that may arise as a part of this person with a disability applying for this job. And we're not going to get into that here, but this case just kind of shows you how it's just a situation where you can see how there may be many more things you have to think about beyond just the ADA and why it really pays to get some good advice before making these decisions. So this is a man who's applying to be a lifeguard for the County of Oakland for one of their public swimming pools. And he has been deaf, unable to hear since he was born. So he's never really become very verbal because he's never heard himself speak. He's never heard any other sounds. And he communicates using American Sign Language. Now, there's a guy who is in charge of the hiring process, but then he's got like a manager that he reports to, and he really likes the guy for the job as a lifeguard, but there's some back and forth essentially about whether he can really do the job, which is essentially a job that only entails being prepared to save somebody's life. So you can see there might be some not ill-intentioned concern about whether somebody who cannot hear at all and doesn't communicate verbally will be able to save somebody's life in the event that they're drowning. To make a long story short, ultimately there's evidence and testimony that suggesting that somebody who can't hear is unable to be a qualified lifeguard is kind of based on a stereotype and a generalization about what it takes to save lives in this particular situation. The thing about being a lifeguard is that when people are drowning, they typically don't yell out, "Excuse me, I'm drowning, please save my life," right? So hearing isn't the main thing. In fact, the main thing that you do as a lifeguard is you have to make sure that your eyes are scanning the area within certain incremental shifts in your vision to make sure you're constantly spanning the whole area of the pool. And so when somebody's drowning, it's going to be something that you see. It's going to be something, if they communicate at all, it's going to be with a hand signal. And this guy is trained in American Sign Language. He's been doing it his whole life. So, and in fact, the court points out that the world record for the most lives saved as a lifeguard was a guy who actually was deaf. And so this case gives us an example of how employers need to be careful to do, in what the court says is an individualized inquiry to make sure the person is qualified for the position, even if they need maybe reasonable accommodations that don't otherwise, negate their ability to do the job. So this just gives you an example of how you've got to be really careful to not make, as an employer, assumptions about a particular situation, and to make sure that you get good guidance before making any decisions about the job or about a promotion or any other serious employment decision. Okay, so with addiction, addiction can also be treated as a disability if it's treated, if it's a past addiction. You can ask about, and in the interview process, you don't really want to ask about disabilities at all, because it's going to give rise to an inference that you're making a decision on that basis. But with addiction, you can ask about current drug or alcohol use, because you don't obviously have to abide somebody who is getting drunk and or high while they're doing the job, especially if it's a very sensitive sort of job like driving a truck or being a train conductor or something like that. Okay, so as I alluded to, this is a sort of a sticky area of the law, so you want to just be very careful and not, there may be a lot of novel situations that nobody else has ever really had to deal with, at least in a contentious way. So it's an area where you want to make sure you get some good advice before making any serious decisions. And then also remember that even if you're not covered by the ADA, or you don't think the ADA is going to pose a problem in this situation, there may be other areas of law or even state and local regulations that may come into play, or if you're the government, constitutional issues that may come into play if you're otherwise discriminating against somebody for simply having a disability when they're otherwise qualified to do the job.